Hello, this is attorney Charles Green, and today we're going to talk a little bit about the basic divorce consultation in Los Angeles, California. Well, initially when many people come to me, people who have not been served and are just interested in a divorce, the most common question I get in the beginning is, does it matter if I start or if my spouse starts the divorce? And the answer to that question is the person who starts the divorce is called the petitioner. And the petitioner goes first in a trial. So there are pros and cons to being the petitioner or the respondent. The petitioner gets to set the tone of a trial because they're going to put their case on first. The respondent kind of gets the last say because they put their case on in front of the judge after the petitioner is done with their case. So there is a difference in being the petitioner or the respondent. It's not enough usually to be the one to pull the trigger on a divorce if you're not sure about getting divorced. So if you are sure, then just do it. Don't worry about if you're first or second. That should not be the main concern. However, there are advantages to being petitioner. Like I said, you get to be the first one. So then let's move on next. Who am I? I am a certified specialist in family law with at this point approximately 18 years of experience doing family law litigation and at times other types of litigation here in the California state courts and also the bankruptcy court. However, most of my work, the majority of the work that I do, is family law litigation. I have extensive experience as well as an accountant. I was a professional auditor. I have an MBA in accountancy, and I've worked for many years prior to becoming an attorney. I worked as a certified public accountant in the past. Now I bring that experience to my law career, and having that experience is very, very helpful in the divorce world, in the legal implications and analysis of a divorce case. I am able to learn a lot about a couple's financial situation by looking at their tax returns. Almost everything hits the tax return in some way. So if you work back from a tax return, if you understand how to read a tax return, you understand what capital gains are, pass-through entities, S corporations, LLCs, then you can work backwards and find where those income streams are coming from and attempt to identify all the assets of a community. And the husband and wife, the couple, that is called their community. What they have accumulated during their marriage is their community, as well as sometimes separate property that they may have converted into community property through various means. Another common point that many people ask on their initial consultation is, I don't want my spouse to get anything. Well, that's not going to happen, and any attorney that tells you, sure, don't worry about it, we won't give her anything, we won't give him anything, they're not giving you honest counsel. What you need as a divorce litigant is you need someone that is going to move away all the folklore, all the fables that you've heard from your neighbor and from your aunt and uncle, your big brother. Move all that away and tell you what's really going to happen. And what's really going to happen is it's not reasonable to say, my spouse is not going to get anything. The correct way to approach it is to make sure that you get what you are entitled to under law. And if there are areas of gray law that is not clear in its application to a particular asset or debt you might have, or a transaction, or some community asset, that your attorney pursues it in your best interest in an ethical, diligent way to get you the most favorable financial and emotional outcome. Another important point in many divorce cases is the children. And again, it's not usually practical to say, I don't want him to ever see the children, or she's not a good mom, she can't take care of the children. Well, each child, for the most part, this is the father or mother that they have, and there is a very wide spectrum of acceptable parenting. Some of it might not seem acceptable to you, but to the court system it still might be acceptable parenting. But in situations that warrant an investigation of one or the other parent's allegations about the way their partner is parenting the children or child, we have evaluations. And those evaluations can usually get to the bottom of what's going on in a particular family or in a particular parenting style, and help to guide ultimately the parents to be better parents, to communicate better, to be more sensitive to what's in the best interest of the child. So what I hope you got out of this little talk that I'm giving today is that it's not unusual for one or the other litigants in a divorce to want to take a very aggressive stand when they initially meet with their attorney, when they pick an attorney and decide to develop an attorney-client relationship. However, a good attorney is going to explore your concerns with you, but at times counsel you as to what is the law, what is the public policy. And the public policy with children is that both parents are supposed to have essentially a meaningful relationship with the child and regular contact. Now, what frequent and regular contact means is subject to some interpretation. Does that mean a 50% timeshare for each parent, or does that mean one can still have 20-25% and still have frequent and regular contact? Well, at times, yes, you could have frequent and regular contact and not have a 50% timeshare. We see that in some cases with a move away, where one parent is out of state or too far away for regular weekend visits, but we compensate for that with extended summer visits, extended holiday visits, and we do the best that we can to give each parent frequent and regular contact with the child. The health, the mental health and physical health of the children is always a priority in the family court, and it should be a priority to most divorce litigants. Sometimes people get overwhelmed by the changes going on in their life, and they forget that the little children or even teenagers are severely impacted by that. And a good attorney can sometimes help you be refocused to think about what this divorce is doing to the children, and in some cases how an asset division at the end of a case can affect the children. Maybe you have, for example, I've seen adult children living in a former family home with one or the other of the divorce litigants, and they're talking about selling that home. But if you have a child who's attending a local community college and working 2 part-time jobs to help pay for that, and now you're going to take away their housing, you might be really hurting that adult child's ability to finish college. So these are things you have to consider in a divorce, and try to find solutions that have the least negative impact on the adult children and the divorce litigants, or in many cases minor children. So sometimes selling the home or causing a child to move to a different area can be avoided if the parties are willing to negotiate and work things out. For example, maybe they'll end the divorce, but we won't sell the family home for 3 to 5 years. Or we'll determine what the interest is for both spouses in the family home at a future time. But we'll divide other things. We'll divide retirement accounts, and we'll come up with a custodial timeshare for parenting of minor children. Maybe institute spousal support orders and child support orders. But sometimes it's best to set some orders out a little to a future date for the financial and emotional and developmental health of the couple's children or for one of the other spouses. Now, one last quick point to talk about on the initial divorce consultation is what happens if my mom or my dad gave me money to buy the family home? Well, in that case, if you can prove it, if you have records, or if your spouse is willing to agree that those are the true facts, you will usually get a reimbursement when that asset is sold of what your separate property, either an inheritance or money you had before the marriage or money you got from your parents, if it was a present to you alone, not a present to the couple, then you will get that money back under what's called a Family Code 2640 claim off the top of the sale of that asset. So that's also one of the most common questions people ask is my mom or my dad or I earned that money before I got married and I want that money back that I put in for the down payment on the family home. Well, usually we can get you that money back, but we need some proof. Okay, well, I hope this little talk was helpful, and I'll be doing some more in the future, discussions of family law and legal issues that have crossed my desk on a regular and frequent basis. And if you need to employ or discuss the services of a certified specialist in family law in the state of California, practicing in the Los Angeles area, feel free to call Charles Green at 213-387-4508, and you could come to this office and we can have a little talk, an initial consultation. Thank you very much and have a good day, and I hope this was helpful.